Good afternoon, and thank you for registering for today's webinar on patient and employee disability issues. Today's session will be led by the co-chair of Garfunkel Wild's Litigation and Arbitration Group, Roy Breitenbach. Roy specializes in appellate litigation, employment law, antitrust, complex commercial and real estate disputes, and healthcare reimbursement disputes. Roy has published extensively in various well-regarded industry journals and speaks frequently on litigation strategy, employment issues, and payer-provider matters. Today's presentation will run approximately 45 minutes with questions at the end. Please use the chat box in the upper right-hand corner of your screen to post questions. We will answer as many questions as possible at the end of the presentation. All others will be answered via email. A replay of this presentation will be posted to the Garfunkel Wild YouTube channel, and we will email that link in the coming days. Before I turn the presentation over to Roy, I'm pleased to announce that Garfunkel Wild, together with Priority One Group, will be presenting the 4th annual ASC Symposium on October 20th. For more information about the sponsorship or registration, please visit the Symposium website at newyorkmetroasc.com. Now, over to Roy.
Hello, as Cynthia said, my name is Roy Breitenbach, and I'm a partner director here at Garfunkel Wild. The title of today's presentation is Patient and Employee Disability Issues. How can ASCs resolve these challenging issues? So we're going to talk about both patient disability access issues as well as employee disability issues. So let me go now to the kind of the general overview of what we're going to be doing. I'm going to start off with 2 hypotheticals, one patient, one employee. Then we'll get into the meat of the presentation, which will first talk about patient disability issues. We'll start off with the obligations of healthcare providers, talking a lot about what the Americans with Disabilities Act requires. And then it'll talk about the 3 main areas in which healthcare providers have to provide reasonable accommodations to patients who are disabled. And those 3 areas are healthcare providers have to make changes in policies and procedures when they're required. Healthcare providers have to provide auxiliary aids and services when they're needed. And then we'll finally talk about policy, procedure, and training issues. We'll also talk about, in connection with the Americans with Disabilities Act, we'll also talk about the removal of architectural barriers. And then we'll also talk about, the second half will be employee disability issues. We'll once again talk about the obligations of healthcare providers in this area. We'll talk about the definition of who is a disabled employee. We'll talk about the concept of reasonable accommodations to employees who are disabled. And under that, the all-important interactive process requirement. And then we'll finally talk about policy, procedure, and training. What I'd like to do first, though, is to give you 2 fact patterns, one for a patient access issue, one for an employee who has a disability issue, to provide an overview as to why this is an important area of the law and some of the issues that come up. So let me first talk about a disabled fact pattern. So here's the story, okay? Suppose it's an orthopedic group, all right? An orthopedic group, and you can translate this to anything, an ASC, an orthopedic group, any healthcare practice, okay? And a visit is being scheduled. That visit could be a surgery for an ambulatory surgery center, an outpatient appointment, and the patient's deaf. Only the practice or the ambulatory surgery center does not know it. So the first person to call to schedule the appointment is the deaf patient's son. And the deaf patient's son calls, says, I'm making an appointment for my mother, and says that my mother is deaf and needs a sign language interpreter for when they come in for to receive the care. However, the front desk or intake person for the practice of the ASC has not been trained on how to respond to that, gets this question out of left field, and says, believing it's accurate, we don't provide interpreting services, or says, I don't know about interpreting services, I don't know where to get it, or worse yet, says, well, we don't provide these services, I think you're going to have to go for the hospital to get it. All three of those responses are wrong and will subject the healthcare practice or healthcare facility to a significant amount of liability. First of all, hospitals and other healthcare facilities are required to provide interpreting services in situations for patients who are deaf, in which they need those interpreters to effectively communicate with the medical staff about their medical treatment, condition, and prognosis. And it is not an answer for these practices to say we don't provide interpreters. As we'll discuss later, that is even the case if the cost of providing the interpreter is significant, and in many cases more than the visit or the reimbursement will be for the treatment provided. There is an absolute obligation in most circumstances to provide interpreting services to patients who are deaf when they are receiving health care. So that's an important thing to come to mind. And if the front desk person responds in the way I talked about, by either saying, we don't provide an interpreter, I don't know where to get one, you'll have to go to the hospital, that patient, that facility will be subjected to significant enforcement activity by either the United States Department of Justice, your local state's Human Rights Commission, plaintiffs, disability rights advocacy law firms who actively test to see that facilities are complying with their obligations under the Americans with Disabilities Act, or even a lawsuit by a private plaintiff who are ever increasingly bringing these types of lawsuits to vindicate the rights of disabled people. And by the way, if we extend this fact pattern further and we say that, notwithstanding the response of the front desk person, that we don't provide an interpreter, and the patient comes to the facility, and when the patient comes to the facility, because no interpreter is provided, the son is providing the interpreting services for the patient, and the procedure goes fine, there are no problems, the facility is still liable under the Americans with Disabilities Act. It is not the answer in a situation in which an interpreter is required for a facility, a healthcare facility, to require a patient's family member to interpret. And even if the visit goes fine and there are no adverse medical consequences, there still could be liability and damages for emotional distress because the patient did not receive an independent, qualified sign language interpreter. So let's now go out to the disabled employee fact pattern. So we have an ASC, and we have a nurse in that ASC. And the nurse starts working for the practice, let's say, around 2010, starts working for the facility, and does a good job, but every once in a while there are little blips in the road in which the nurse's disciplinary record is not good. Some minor issues, some minor problems, maybe some problems with time and attendance. But never comes and says anything to the practice as to the reason why, accepts the discipline, and moves forward. Now, Hurricane Sandy happens in late 2012. The nurse's home has some significant damage in Sandy, and the nurse's parents' home is totally destroyed in Sandy. So the nurse takes some time off to deal with that. But the nurse is not then coming back to work. So the facility reaches out several times to them to the nurse. The nurse still is unwilling to come back to work, raises all kinds of issues about having to clean out the parent's home, all kinds of problems getting up and running after Sandy. Facility is trying to reach out and accommodate the employee, so extends leave several times, tries to work with the employee. Finally, the facility says we can't wait anymore. We need this nurse to come back to work. Tells the nurse if you don't come back the next day, you're going to be disciplined. The nurse then says at that point, for the first time, that I have some significant anxiety associated with Sandy. I've had anxiety for a long time, and I can't come back to work. Facility thinks it's just an excuse that the patient is that the nurse is giving to avoid having to come back to work, and the facility fires the nurse. This fact pattern would subject the facility to a significant amount of liability in the area of employment disability discrimination, because once the nurse says that they have some anxiety, it is the obligation of the facility to engage in what is known as the interactive process to determine the extent of the disability, to determine whether or not the facility has to provide a reasonable accommodation for the disability, and to generally see whether or not the whole issue can be resolved through the interactive process. By not doing that and taking immediate disciplinary action, there is an issue and an inference of disability discrimination, which could subject the practice to significant liability, both for back pay, emotional distress, and the costs of the suit. So we'll talk about all these issues in a little bit more detail as we move on, but let's now go to the first section of the main part of the presentation, which is talking a little bit about the Americans with Disabilities Act. And then we'll go into disabled patients, and then we'll do disabled employees. Most of what we're talking about today is focused on the Americans with Disabilities Act. Okay, that is the basic act which obligates healthcare providers to do certain things with regard to disabled patients and disabled employees. The Americans with Disabilities Act was enacted in 1990, so it's been around a little bit more than 25 years. And there's three main titles that you have to worry about or focus on with the Americans with Disabilities Act. Three main sections. Title I, which deals with and bans discrimination against the disabled in employment. So that's when the ASC is acting as an employer, I should say. Title II, which deals with discrimination against the disabled by governmental entities, which shouldn't really apply to ASCs, but we'll talk a little bit later about how there's some obligations under Title II that now apply to healthcare providers because of the Affordable Care Act. And then Title III, which deals with discrimination by public accommodations, discrimination against the disabled by public accommodations. And as we will explain in a little bit, healthcare practices, because they're open to the public and provide service to the public, as well as ambulatory surgery centers, fall within the definition of public accommodations, and therefore have to follow Title III of the Americans with Disabilities Act and avoid disability discrimination in dealing with their patients. This is the Americans with Disabilities Act, which provides the basic federal obligations that healthcare providers must follow, but you can't forget your local laws, all of which have their own requirements about disability discrimination that in some cases are more stringent than the Americans with Disabilities Act. And we'll talk a little bit about that as the presentation moves on. And the key local laws there are the New York State Human Rights Law, which obviously governs ASCs that will be located in New York State, the New York City Human Rights Law, which also applies to those ASCs located in the city and has the most stringent requirements prohibiting discrimination with regard to the disabled of any place in the country. the Connecticut Human Rights and Opportunities Act, which obviously governs ASCs in Connecticut, and the New Jersey law against discrimination. Okay, so let's first talk about the obligations regarding disabled patients. Okay, so this would be, again, Title III of the Americans with Disabilities Act. And it's illegal under this act for any business, building, or other place that is open to the public to discriminate against people with disabilities. So, as I've said, the definition of a public accommodation includes any entity that provides services to the public. So all healthcare facilities and all healthcare practices would be considered public accommodations under the law and are obligated to follow Title III of the Americans with Disabilities Act. The next point to focus on is Title III doesn't just prohibit discriminatory conduct. It's not just that the Americans with Disabilities Act prohibits a public accommodation or healthcare practice from doing something that's intentionally discriminatory towards a disabled person, such as by putting a sign up in the facility that we don't treat blind people, or by saying that, we will provide care to somebody in a wheelchair. It's not just that type of classic intentional discriminatory conduct that you think about when you talk about the anti-discrimination laws. What was new about the Americans with Disabilities Act is that it has an affirmative obligation. Title III requires providers to undertake affirmative actions. They're called reasonable accommodations to eliminate barriers that prevent persons with disabilities from fully enjoying their services. So, since a healthcare provider provides healthcare services, if there's a barrier for a disabled person to receive those services, the Americans with Disabilities Act obligates healthcare providers to take reasonable steps to remove those barriers so the disabled person can receive the healthcare services without those barriers. And if the practice or the facility or any healthcare provider fails to provide these reasonable accommodations, fails to remove these barriers, that is defined under the Act as disability discrimination. So you have an affirmative obligation to make a reasonable accommodation to remove these barriers, and if you don't, you've engaged in disability discrimination and you're liable for disability discrimination. It's kind of a new concept in the law, this affirmative obligation to make reasonable accommodations. And it is what makes the Americans with Disabilities Act so complex. So there's three main types of reasonable accommodations that are important for healthcare providers, right? These are the three types of barriers that have to be removed. First are policies or procedures. If your practice or facility has policies or procedures that present as a barrier to a person who is disabled, you're required to change those policies and procedures as long as it's reasonable to do so. So it's required changes to policies or procedures. The second one is the provision of auxiliary aids and services. If there's a barrier to a disabled person receiving your healthcare services, and if you provide them with something else, an auxiliary aid or service that's reasonable to provide, that would enable that barrier to be removed, you as a healthcare practice or facility are obligated to provide that auxiliary aid and service. The classic example of this is the provision of a qualified sign language interpreter to a patient who is deaf. And because that's a big area for healthcare providers, we'll talk about that in great detail later on. And the third one, which applies to all public accommodations, not just healthcare providers, is the removal of architectural barriers. So if your facility is designed in such a way that there's a barrier for the disabled person to receive the healthcare services, and removal of that barrier is reasonably achievable or readily achievable, the healthcare practice or the healthcare facility has to do this. In many cases, the removal of architectural barriers may not be as big of a deal for ambulatory surgery centers, many of whom, particularly in New York, for example, have to comply with the Article 28 hospital architectural requirements, which incorporate many of these avoidance of architectural barriers concepts under the ADA. So let's now talk about required changes to policies and procedures. Well, one of the classic ways to talk or look at required changes to policies and procedures is the issue of companion animals, okay? I'm sure that virtually all, if not all, of the ASCs that you work for have a policy, whether it's either an express policy or an implied policy, that animals, pets, are not allowed inside the facility, right? A person cannot bring, under ordinary circumstances, their dog, for example, into the ASC waiting room, right? You know, and there's a lot of legitimate, perfectly valid reasons not to do it, right? You're concerned about disrupting other patients who may have allergies. You're concerned about the health, potential infection for introducing a pet who may have some type of communicable disease. There's a whole host of legitimate reasons why that's not the case. So you have this policy preventing or prohibiting patients from bringing in their companion animals or pets into the facility. Now, if you have a patient who is blind and is relying on a seeing eye dog in order to get around, your policy and procedure prohibiting animals from entering the facility is a barrier for them to receive the healthcare services, right? They need the animal to get into the facility and to go into the facility, but you have a policy preventing them from doing so. So in that circumstance, the Americans with Disabilities Act would obligate the facility to make an exception or to change the policy to permit a seeing eye dog for a blind patient to come into the facility to accompany the blind patient. Now, accommodations under the ADA must be reasonable and cannot present an undue burden to the facility. So the obligation to permit a seeing eye dog to come into the facility are necessarily limited by certain restrictions. One of those restrictions is the seeing eye dog can only go into places in which the patient would be permitted to go with a companion. So, for example, you have to allow the seeing eye dog to come into the waiting room. You may have to allow the seeing eye dog to accompany the patient when they go into the pre-op holding area. But you don't have to allow the seeing eye dog to go into the operating room with the patient because, one, the patient may not be conscious and therefore be relying on the seeing eye dog when they get into the operating room. And number two, you don't ordinarily allow a human companion to accompany a patient going into the operating room. And what's unique about the issue of companion animals is that the Americans with Disabilities Act focuses on seeing eye dogs. It was the time in 1990 when the act was passed, that's what the whole service animal field was focused on. Since that time, we have a whole host of other types of service animals or companion animals that help patients with a wide variety of conditions. Not all of them are protected under the Americans with Disabilities Act. They may be protected under local laws prohibiting disability discrimination. So if you're not dealing with a seeing eye dog, we urge you to reach out to your legal professional to go through the issue, okay? We'd be happy to go through the issue with you because there are some other technical requirements that would apply. But that's kind of a classic example of the seeing eye dog of where the Americans with Disabilities Act requires a change to policies and procedures. Another example would be altered intake procedures. For example, If you require patients to make appointments by phone, but you have a patient who is deaf, you may have to change that policy to allow that patient to make an appointment by some other means. So those are required changes of policies and procedures. Let's now talk about the provision of auxiliary aids and services. As we talked about it, in order to provide equal access, a public accommodation must provide auxiliary aids and services for people who are deaf and hard of hearing when needed. So, what equal access means, the whole concept is equal access. You have to provide to a person who is disabled, like for example, a person who is deaf, the same access that they would have to the healthcare services as a patient who was not deaf. So equal access equates to effective communication about the patient's medical condition, treatment, and prognosis. Now, this is not, as many people believe, a 24-hour, 7-day-a-week obligation. You do not have to have a qualified interpreter shadow the patient every minute of every treatment. The key is, though, is to provide an interpreter for key interactions, and we'll talk about that later. But before we do that, let's talk about, in general, the concept of auxiliary aids and services. Under the law, it includes qualified interpreters, could include note takers, could include specialized written materials. Like, for example, for a patient who is blind, providing policies, procedures, written documents in Braille may constitute an auxiliary aid. The type of auxiliary aid or service provided will depend upon what's needed in a particular situation. For example, interpreting services very frequently depends on the deaf person. Not all deaf people rely on interpreters. Some deaf people prefer to communicate in writing. Not all deaf people are fluent in American Sign Language. They may have never learned sign language, or they may use a different sign language system. So it's really dependent upon the patient. However, you really have to be careful when you're a healthcare provider in the area of providing a qualified interpreter, because going way back to when before the Americans with Disabilities Act was enacted, the Department of Health and Human Services said it would be extremely difficult for the healthcare provider to demonstrate in certain service settings that effective communication is being provided in the absence of interpreters. So the federal government believes it is fundamentally a default to provide interpreters to most patients who are deaf. Now, there's an interesting issue to talk about with regard to the Affordable Care Act. Before the passing of the Affordable Care Act, a facility, if a patient requested, let's say, an interpreter, and the facility believed they could provide effective communication through some other means, let's say, for example, by the exchange of notes, and the facility did provide the exchange of notes and could establish that there was effective communication, the fact that the facility did not honor the patient's request was not important and did not establish liability, as long as the method that the facility did use did provide effective communication. However, with the passing of the Affordable Care Act, for those healthcare providers who do take as insurance the plans that are on the exchange, so the healthcare providers are subject to the provisions of the Affordable Care Act, you have to give due deference to a patient's request. So if a patient asks for an interpreting service and you as the provider believe that you can still provide effective communication through note taking or through the exchange of written notes, you have to give due consideration to what the patient's requesting. And if you're not going to follow what the patient requests, you have to have a legitimate reason. If you don't have a legitimate reason, it doesn't matter whether or not the note exchange was effective. You still have violated the Americans with Disabilities Act. So that's an important change to keep in mind. So let's talk about who is a qualified interpreter. Qualified interpreter has to interpret effectively, accurately, and impartially. You don't have to have certification from any formal agency. As long as you're qualified, you can use all the necessary vocabulary. you know how to interpret, and you're impartial. That's why family members oftentimes are not considered qualified interpreters because they will not act impartially. And there's a concern about them maintaining confidentiality. It is generally best practice to avoid using any family member as an interpreter unless the patient absolutely requests it and you document that request. And in no circumstances should you ever use a minor as an interpreter. Okay, so as we said before, providing an interpreter in a healthcare setting is not a 24/7 obligation. You don't have to have an interpreter shadow for the entire time. It's only when there are key interactions when effective communication is needed. So that would be when discussing a patient's medical condition, symptoms, and history, reviewing or explaining or obtaining informed consents, healthcare proxies, and DNR orders, explaining medications being prescribed, dealing with complex billing and insurance issues. This is not an exhaustive list. There are others that could be included, but anything in which it's a complex interaction and the patient, you would want, it's really about the medical condition, prognosis, treatment, or other important issue. As I said before, you have to be careful when you're providing a sign language interpreter because there are multiple sign language systems. While the predominant one in the United States is the American Sign Language, not everyone uses it. You have to have an understanding of precisely what your patient needs to make sure that you provide an interpreter that meets those needs. And similarly, you also can consider using video remote interpreting, which is interpreting by means of a Skype-like connection, where the interpreter doesn't come on site but is in a remote location. There are pros and cons. It's very good because you don't have to wait for an interpreter to show up. It's always on call. You're only paying for it when the patient's there. But you need to have high-speed internet access, a sufficiently large screen, trained personnel to set it up, and a procedure to do if the patient objects. There are certain contraindications to VRI. If the patient has a limited ability to see the video screen or a limited ability to move head, hands, or arms, or the patient has visual limitations, cognitive or consciousness issues, or pain issues, all may be reasons why you don't want to use VRI. The final thing to talk about with regard to patient access is the removal of architectural barriers. What are architectural barriers? Well, there's something that prevents a patient with disabilities from fully accessing the provider's services, okay? And they're more than true architectural barriers, not just physical impediments such as the size of hallways or the size of doorways. Could be inaccessible medical equipment, signage that doesn't accommodate people who are deaf. All of those things would fall under the rubric of architectural barriers. As a public accommodation, you're obligated to remove architectural barriers in certain circumstances. First of all, when you're constructing a new facility or substantially renovating an older facility, you must comply with the accessible design guidelines issued by the United States Department of Justice. The ones that are operative now are the 2010 guidelines. You need to comply with them. Also, even if you haven't changed your facility in a long time, you must still undertake readily achievable barrier removal at existing facilities. And typically, the most common readily achievable barrier removal is to ensure that there is an accessible path of travel from the entry to the facility all the way back to the treatment areas so that a patient with limited mobility who is blind or maybe in a wheelchair can readily access and go follow that accessible path of travel into the back where there's treatment. Also, provision of a handicapped bathroom would be a readily achievable barrier removal. Signage is also a readily achievable barrier removal, making sure you have signage that's at the right height from somebody with a wheelchair. Oftentimes, too, taking a receptionist desk and lowering it to the right height is also something that's important. Appropriate signage, that is braille or uses symbols that are appropriate. And finally, accessible medical equipment. This would be tables that lower to the right height to enable wheelchair transfer, where the sides come down to assist on transferring, things like that. What happens if you violate the Americans with Disabilities Act? Well, the Americans with Disabilities Act does not allow you to get damages. Title III, dealing with public accommodations, do not provide a remedy of damages. But the Federal Rehabilitation Act, which applies to recipients of federal funding, and most healthcare providers participate in Medicare or Medicaid, so they're subject to the Rehabilitation Act. That does allow for the recovery of compensatory damages, meaning that if a patient can show that they've been damaged by reason of the failure of the facility to make a reasonable accommodation, they can sue for damages, and if they're successful, they get their attorney's fees, but they have to show that the facility was deliberately indifferent, meaning that it wasn't just negligence, but something more, that they were aware that there was a problem about providing accessibility and they decided to do nothing about it. And of course, there also may be other state and federal laws that apply. The entities that will enforce the Americans with Disabilities Act and the Rehabilitation Act include private attorneys, public interest law firms, the United States Department of Justice, Office of Civil Rights, the United States Attorney's offices, state agencies such as the Connecticut Human Rights Organization, things like that. Okay. It's important to follow and comply in these areas because there are a lot of enforcement priorities and enforcement initiatives that the agencies are taking. For example, the United States Department of Justice has a barrier-free healthcare initiative in which they're actively pursuing investigations throughout the country to make sure that healthcare facilities are removing barriers to the disabled. You can go on the DOJ's Office of Civil Rights website to see more information about that. There's law firms such as Eisenberg and Baum who are actively seeking cases in this area to bring against facilities who are not providing interpreting services. And finally, there are public interest law firms like disability rights advocates that are aggressively identifying through the use of testers, healthcare facilities that are not complying with their ABA obligations. So the way you minimize the risk in this area is through policy, procedure, and training. You need to have a good policy. By having a good policy and following it, you're avoiding the concept of damages through deliberate indifference. The key to everything with regard to policies is to have a point person at the facility who coordinates all these issues, who's knowledgeable about the disability requirements. A policy also provides a good reference guide for staff and emphasizes the importance of disability compliance. Should cover the obligation to provide effective communication, identify a need, request for auxiliary aids, selection and use of qualified interpreters, use of VRI, and a good complaint mechanism. You need to have good procedures in place, the key of which is the early identification of need. You identify a disabled person early on in the intake process, you can provide what is needed for that patient without much difficulty. Also, aggressive follow-up to make sure that in future appointments you're providing the same level of services. And there has to be good training, using knowledgeable trainers, dispelling myths, making sure that people at the access points, such as intake people, receive training, needs to be sensitive to issues, things like that. Let's talk a little bit about disabled employees in the time we have left. Obviously, an employment decision cannot be based on a disability, and the prohibition against disability discrimination in employment set forth in Title I does have a requirement that requires an employer to make a reasonable accommodation to an employee's disability. The general rule is if an adverse employment decision, such as firing or discipline, is connected to the employee's disability, the employer had to consider whether or not there was a reasonable accommodation that could have been made to rectify the situation. Failure to provide this reasonable accommodation constitutes employment discrimination. So the first thing you have to consider for employment is who is disabled. Well, the definition of disabled for purposes of employment is an employee who has a physical, mental, or medical impairment resulting from anatomical, physiological, genetic, or neurological conditions, prevents the exercise of a normal bodily function, or demonstrates or it's demonstrable by medically accepted clinical or laboratory diagnostic techniques. So this pretty much picks up most things which we would classically consider to be disabilities. There's also the issue of if a person is not technically disabled, but you regard the person as disabled. If the employer believes the person is disabled because of the way they present, you still maybe have liability under the Americans with Disabilities Act or the state laws for disability discrimination. And then there's the issue of alcohol or drug abuse. People who are victims or suffer from alcohol and drug abuse problems are considered disabled while they are in treatment. So if they're in treatment or recovering alcohol and drug abuser, there are certain things that the employer cannot do to them and would constitute disability discrimination. If you have an issue in this area, we urge you to talk to your legal professional because it's a very complicated area. So let's talk a little bit about reasonable accommodations for employers to employees who are disabled. There's an obligation on the employer's part to provide reasonable accommodations to the known disabilities of an employee. Actions taken which permit an actual prospective employee with a disability to perform in a reasonable manner the activities involved in the job or occupation sought. So essentially, what you have to do is if you are aware that a patient has an employee has a disability, and that disability is preventing them from carrying out the reasonable functions of their job, you must, and there's a reasonable accommodation that would enable them to fulfill that function, you have to make that reasonable accommodation. So, for example, classic example, you may have to provide an employee who has a medical condition additional time off with regard to leave to accommodate that condition. Right? Because if you change your policy and you permit a few extra days of paid leave or leave in general that's not paid, you're accommodating the disability. You may have to give, for example, an employee with a wheelchair a desk that is more easily accessible for somebody in a wheelchair. That's a reasonable accommodation. Those are the things you have to take into account. But if the employee still cannot fulfill the essential job requirements with the reasonable accommodation, then there's no employment discrimination. Okay. The key to a reasonable accommodation is the obligation to engage in an interactive process. Once you are aware that an employee is disabled, you need to work with the employee in an interactive process to identify what reasonable accommodations there could be to enable that employee to fulfill his or her essential job requirements. In engaging in this interactive process, there's some things you have to keep in mind. You're not obligated to provide an accommodation if it imposes an undue burden on the facility. So, for example, if it requires you to do something that costs a significant amount of money or alters the way that the facility provides services, it would not constitute a reasonable accommodation. One of the key things in this area is you don't have to create a position where none exists to accommodate a disabled person. You don't have to alter essential job requirements. So if you take an employee's job description and you can identify what's functionally the essential job requirements, you don't have to eliminate them, those essential job requirements to accommodate an employee. Certain changes in policies may be required, some may not, depending on whether they fundamentally alter the nature of the services that the employer provides. And as I said, the classic one is the alteration of time off policies. Training in this area is the same as training fundamentally for in the area of providing reasonable accommodations or avoiding disability discrimination in the area of for patients. It's that you need to document what you do. It's vitally important that when an employee comes to you, indicates that they're disabled, that you document what they say and what the reasonable accommodation that they're looking for is. You get saved and minimize your liability as an employer when you document the interactions regarding reasonable accommodations and disabled employees. You need to show ultimately that you're engaging in an interactive process. And as a result, documentation is key. You have to make sure that supervisors are trained on the requirements of the Americans with Disabilities Act, because supervisors who make offhanded comments or don't accommodate a person's disability will create liabilities for the facility. So you need to make sure that your supervisors fully understand the training and know to defer issues regarding disability to HR so that they can be appropriately documented and handled. Obviously, you need to have a good set of standard written employment policies that documents everything, that provides a good procedure for everyone to follow. You need to be careful and proactive about the interactive process. The key to everything is the interactive process to identify a reasonable accommodation, and your failure to do so can subject you to significant liability. Okay, that's the basic procedure, so I'm not going to go and take a few questions that we've received, and then we can end there. So, one of the questions that have been asked is, how do you handle an employee who is obviously disabled but does not request a reasonable accommodation? And this is a key issue. That comes up, right? You have an employee who you can see or you reasonably believe has a disability, is having disciplinary problems, and could probably use a reasonable accommodation to deal with that disability, but is not asking for one. It's a sensitive subject because, on the one hand, you don't, as an employer, want to create an issue where none exists, but you don't want to take the position that just because the employee didn't ask, you turn a blind eye. So the answer lies in the concept of the interactive process. If an employee is having disciplinary problems and you believe that they may be disabled, you need to start out the conversation about the discipline, probing for whether or not there's a reasonable accommodation that they need. Saying things like, looks like you're having some problems with this. Is there anything we can do to help you? Is there anything you need? It is important to do have those types of conversations and to document those conversations, because it can avoid significant liability later on. If you take a look at the case law in this area, you will see that there is a tremendous amount of cases in which employers kind of turned a blind eye to obvious disabilities and wound up being held liable for employment discrimination. So it's very important to have these types of discussions and ask a disabled employee what they need in a proactive manner so to avoid liability. Next question I have is, how does the Affordable Care Act impact the provision of sign language interpreting services? As I explained before, with the passage of the Affordable Care Act, and specifically Section 1557 of the Affordable Care Act, which deals with civil rights issues, healthcare providers who take insurance that is sold on the Affordable Care Act marketplaces, so that means virtually any one of the ASCs that take insurance, are obligated to follow the requirements of Section 1557. One of those requirements is essentially says that facilities that fall within the definition of Section 1557 no longer follow the requirements of Title III of the Americans with Disabilities Act with regard to the provision of interpreting services, will fall within the requirements of Title II. And Title II governs the provision of the avoidance of disability discrimination by governmental entities. And under Title II, governmental entities are required to give due deference to the auxiliary aid and service choice of a patient. So, prior to the passing of the Affordable Care Act, as we said before, if you are a healthcare facility and your patient asks for an interpreter, and you believe that there's another method, such as note-taking, which could provide effective communication, you can provide that alternative means, that alternative auxiliary aid and service. And as long as you provided effective communication through that alternative means, the fact that you didn't honor the patient's request didn't matter and did not subject you to liability for discrimination. However, with the passing of the Affordable Care Act, you must give due deference to the patient's request. So if the patient requests an interpreter, you have to provide one, unless you have a very good documented reason why you didn't, and you chose to use another method to provide effective communication. So it essentially requires you to be more deferential to the patient. And with the passing of the Affordable Care Act provisions, in almost all circumstances, a patient's request for an interpreter should be honored. And that's all the questions we have, and as time is almost up, I am going to thank everybody for listening. On this, I've put up my bio right here as one of the last slides. It has my email address. Anybody who wants to email me questions or has any concerns in this area, please email me, and I'd be happy to answer them and answer or handle any other questions you guys may have. Thank you very much for listening, and have a nice day.